Ready, start. The Learn Council further submitted that the termination notice was stigmatic in nature, as it was founded upon allegation of submission of fake or fabricated documents. Full stop. Once the terminations was based upon such allegation, it could not be treated as a termination. Simplify the same part look the character of the punitive action and therefore attracted the protections under Article 311 of the Constitutions of India, mandating of a reasonable opportunity of hearing. Full stop. The Learned Counsel for the respondent further submitted that the action of the petitioner in terminating the services of the respondent without holding any inquiry was a violation of settled law. Full stop. The respondent had played upon the judgment of the Supreme Court in Ratnesh Kumar Chaudhary versus Indira Gandhi Institutes of Medical Science and 345, wherein it had been held that where the termination of a probational is founded upon allegation of misconduct, fraud or falsification of documents, such a termination, even if styled as one under Rule 5 upon 1 of the rules, is punitive in nature and liable to be set aside for want of inquiry. Full stop. The court further held that such a punitive termination is vitiated if passed without a regular inquiry affording the employee due to the opportunity and is liable to be set aside for non-compliance with the principle of natural justice. Full stop. We have heard the Learned Counsel for both the parties and perused the record. Full stop. The essential issues that arises for the consideration is whether the termination of the services of the respondent and made under the writ petition 159 2025 rules 5 of the rules was a simple discharge during the probation period or whether it was in fact founded upon allegation of misconduct amounting to a stigmatic and punitive action. Full stop. The said rule is reproduced as under. It is not in a dispute that the respondent had been appointed provisionally to the post of principal pursuant to the recommendation of the UPSC, subject to verification of these documents and the enactment. Full stop. The offer of appointment itself stipulated that the appointment to the said post was provisional and could be terminated if any document was found to be false. Full stop. During the course of such verification, the experience certificate furnished by the respondent was found not to have been issued by the Dev School. On the basis, the petitioner proceeded to terminate his service by issuing a termination notice dated 4th March 2024 under Rule 5/1 of the rules. The said termination notice is the reproduced as the under. Full stop.